from Jeddah to Manama to US-led mediation efforts last year in Switzerland. Through the US-led mediation effort, for example, we succeeded in getting aid to Zamzam displacement camp. With our partners, we have pushed the warring parties, both the Sudanese armed forces and the Rapid Support Forces, to meet their obligations under international law, to protect civilians, and to facilitate unimpeded delivery of humanitarian assistance. Most recently, in February 2025, just weeks before the applicant filed this case, the UAE co-hosted with the African Union and others a high-level humanitarian conference for the people of Sudan, with the participation of the United Nations Secretary General. In stark contrast, the applicant has single-mindedly pursued a military victory at the expense of a peaceful resolution to this conflict. They rejected the UAE's offer to establish a field hospital in Port Sudan to alleviate the suffering. They rejected calls to return to talks in Jeddah. They walked away from discussions in Manama. They refused to attend the US-led mediation in Switzerland. So when the applicant suggested this morning that it had no choice but to file this case, that is just not true. The applicant rushes to this podium in The Hague, but for 2 years, it has left its seat at the negotiation table empty. Mr. President, against this context, the idea that the UAE is somehow the driver of this reprehensible conflict in Sudan could not be further from the truth. This case is the most recent iteration of the applicant's misuse of our international institutions as a stage from which to attack the UAE. At every occasion, including here today, the applicant has leveled allegations that are at best misleading and at worst pure fabrications. Allegations which the UAE has conclusively rebutted, including as documented in our letters addressed to the President of the Security Council. This reflects an irresponsible pattern of behavior. Rather than working for peace and ensuring that humanitarian assistance reaches people in need throughout Sudan, the applicant has consistently sought to distract attention from their own culpability by blaming others. The applicant would rather come to this court than take basic steps to support the Masalit people. They have refused to allow the United Nations to establish a permanent international humanitarian presence anywhere in Darfur. The applicant must cease its deliberate and indiscriminate attacks on civilians. This obstruction of humanitarian access and its other violations of international law must stop. Mr. President, members of the court, following these opening remarks, Counsel for the United Arab Emirates will now address you in the following order. First, Professor Mathias Forteau will show that the court manifestly does not have jurisdiction in this case. The sole basis of jurisdiction invoked by the applicant is Article 9 of the Genocide Convention. It is clear, including from the case law, that provision cannot confer jurisdiction upon the court, given the United Arab Emirates reservation. Professor Forteau will be followed by Sir Michael Wood, who will respond to what the applicant has said by way of legal argument to claim that the court has jurisdiction in this case. It is clear beyond doubt that there is no jurisdiction. We therefore call upon the court to remove the case from the general list. Lastly, Ms. Alison MacDonald will show that even if the court had jurisdiction, which undoubtedly is not the case, the applicant has not begun to establish that the other criteria for the indication of provisional measures have been met. In particular, the claims made by the applicant lack all plausibility. The applicant has not produced a shred of evidence to support its outrageous assertions. Our agent, Ambassador Amir Al-Hafeiti, will then make concluding remarks and read out our final submissions. I thank you, Mr. President. I now request that you invite Professor Forteau to the podium.
I thank the co-agent of the United Arab Emirates for her statement. I now invite Professor Matthias Polto to address the court. You have the floor, sir.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. Mr. President, honourable members of the court, it's an honour for me to appear before you this afternoon on behalf of the United Arab Emirates. As your court is increasingly busy, we have to use as little of your time as possible and focus on the main points. The main points are very clear in the current case. Given the principles that rule over your jurisdiction, there is obviously no grounds for jurisdiction in the current case. Therefore, the case must be struck from the general list at this very stage of the proceedings. According to well-established jurisprudence, the court has jurisdiction in respect of states only to the extent that they have consented thereto. When a compromissory clause in a treaty provides for the court's jurisdiction, that jurisdiction exists only in respect of the parties to the treaty who are bound by that clause. However, in the present case, it is manifest that the compromissory clause relied upon by the applicant manifestly does not bound the parties. Indeed, as it acceded to the Genocide Convention in November 2005, the United Arab Emirates expressed a reservation to the compromissory clause in Article 9 of the Convention. It follows that the article is not in force between the parties to the proceedings and therefore cannot establish the court's jurisdiction. This manifest lack of jurisdiction also appears in the very wording of the application instituting proceedings. The applicant refers to Article 9 of the Convention, the Genocide Convention, as the only grounds for jurisdiction, but also indicates that the United Arab Emirates have expressed a reservation to said Article 9. Thus, the application implicitly but necessarily states that the court has no jurisdiction. Now, Mr. President, I could leave it at that because that settles the matter. But seeing as against any reasonable approach, the claimant stated this morning that it was entitled to refer the matter to the court, I have to explain why there is manifest lack of jurisdiction in the current case. I will then draw the consequences that you have to to come to and draw the conclusions in the current proceedings before I make a few final comments. As concerns jurisprudence, and regardless of what the applicant's counsel stated this morning, the facts are very clear and simple. They all point in a single direction. Manifest lack of jurisdiction on your part and a fortiori your lack of prima facie jurisdiction. Mr. Wordsworth artificially split hairs this morning to get you to believe that the issue of jurisdiction would be very complex in the current case. The obvious purpose of his presentation was to bypass your well-established jurisprudence on the case. And I insist, because it relates to the objective issue of your jurisprudence, of your jurisdiction, sorry, this jurisprudence does not rely on the arguments that he put to you, contrary to what he said. Your jurisprudence is perfectly clear. The court lacks jurisdiction whenever there are reservations to Article 9 of the Genocide Convention. As I will say and show you in a few moments, that is what you found in 1999 in the legality of use of force cases, and again in the 2000s in the DRC against Rwanda case, and something that you in fact confirmed very recently in 2023 in the allegation of genocide cases. You simply simply need today to apply this well-established jurisprudence, a jurisprudence that is an expression of the balance reached decades ago in treaty law. But before I come to the effect of the UAE's reservation, let me first of all state and recall that Sudan claims as sole grounds for jurisprudence Article 9 of the Genocide Convention. Therefore, should the article not apply, the court would necessarily lack any jurisdiction. Only the consent of the respondent could establish jurisprudence under Article 38, paragraph 5 of the rules of the court. But as was clearly stated, included in the letter sent by the UAE to the court on the 11th of March, the UAE have not given consent and do not intend to do so. The sole grounds claimed for jurisdiction by Sudan in the application, Article 9 of the Genocide Convention, was the object of a reservation expressed by the respondent when it acceded to the convention. And the effect of the reservation is obvious. Under the well-established rules of treaty law, this reservation renders Article 9